Okay, welcome everybody. We're about to begin. I'll just put my webcam on. Are you seeing me? Great. That looks like a yes. Thank you very much. I'm not seeing me. All right. Look, thank you everybody for attending this this inaugural WILPF Australia webinar. I hope you enjoyed the slight bit of excitement at the start of this. So I'd like to begin by introducing you to the topic: International Human Rights Law, International Humanitarian Law and Complementarity, a feminist approach. And I would like to acknowledge the traditional owners of the lands across which this webinar will be travelling. There will be very many. I'd also like to ask you, as we start off, if you would like to type into the question box down below, first of all, oh, there's my video. First of all, whether you can hear me okay. From a couple of people, if you could do that, that would be terrific. Great, thank you. And then what would be really lovely to do, if you'd like to type into that question box your name, the country you're from, and actually whether you're a WILPF. You might like to put in WILPF too if you happen to be related to WILPF or a WILPF member. That'd be terrific to give us a sense of how far this is reaching in this community. So we've got Nathan from Australia. Marie, WILPF Australia. Trish, someone from Germany. Trish from Australia. It's wonderful. Raylene from Australia, Elisa from Italy, Georgia from Nada from Croatia, Sophia, Sarah from Finland. Wow, it's beautiful. Wow, it's a truly international community. So I thank you very much, and how appropriate for a topic which is also, it crosses all countries and all divides. Excellent. So this theme, as you know, is a critical one as we grapple with the emergence of new kinds of conflict and humanitarian issues, and many challenges for top-down approaches in dealing with the injustices and particularly of women in conflict. So we'll be joined tonight by, we'll have main presenter is Jane, and who I'll introduce you to shortly, and then also Barb Dwyer, the President of WILPF Australia. And I would invite you during the evening to type in questions, because we'll have a Q&A section at the end of the evening. So first of all, I'd like to, my name's Chris Henderson. I'm the National Communications Coordinator for WILPF Australia, and I'll be facilitating today's webinar. Before we get started, I'd like to just go over a couple of technical aspects. And I'll move this slide, and welcome. A couple of technical aspects. You're all muted, and that is the way it's meant to be. So you're in listen-only mode. You should see a question box down the bottom, which you should have found to be able to type in questions. If you can, if you need to raise your hand at some stage, I think mostly we'll probably be working in questions into the question box and reading those out at the end. But it may actually be also possible to do some voice questions too. If you have a forced quit, if something happens for some reason and you get out of the webinar, go to that email that you received and simply log back in again and see how that goes. And just to let you know that we are recording. So this webinar will be available online from the WILPF website afterwards. So great, thank you. So next. This seminar, as you know, this webinar is presenting in terms of IHL, IHRL and complementarity, a feminist approach. And I'd like to introduce you first off to Barbara O'Dwyer, the President of WILPF Australia, who is going to be, yes, just giving us a little bit of context. Barbara spent 27 years working in AusAid on UN and humanitarian peace and conflict programs, and she specialised in gender and peace building, and also the areas of violence against women, particularly violence against women in conflict situations. So beautifully placed for this evening's conversation. She was gender advisor for some time and has carried out a number of consultancies focused on the gender dimension of crisis situations. And since 2009, she's been president of WILPF Australia, and she's played a very long role since around 2002 in advocating for the Australian National Action Plan on Women, Peace and Security, and continues to play key roles in that area. So I welcome Barb. And let's have a look.
Can you
Yes.
hear me okay?
Yes, okay. Barb, you're coming in now, thank you.
Thanks. And I'm sorry you just have a photo of me because my video and my microphone don't work at the same time.
Actually, Barb, if you'd like, if it's possible to be a little closer to the microphone, that might assist.
I don't think I can get much closer than that, has it?
That's better already, thank you.
Okay. Well, look, welcome everybody. This is really very exciting to have our very first webinar from WILPF Australia. I've sat in or participated in so many WILPF International webinars, and it's always seemed like a very exciting event. So I hope everyone else across the world who's participating in this feels the same way. I just wanted to put the whole subject of IHL and international humanitarian law into some context, so a WILPF context, because both these subjects are not they're not necessarily, particularly IHL, it's not necessarily something that people are familiar with. So just so that you can see how they fit in with WILPF, I just wanted to give a bit of an overview. So WILPF's foremothers said that in order to achieve peace, the causes of war must be eliminated, and economic and social systems based on profit and privilege must be transformed into societies based on political and economic equality, the participation of women and men, both women and men, and justice for all. These objectives are as valid today. WILPF's aims are to bring together women of different political and philosophical beliefs who are determined to abolish the causes and the legitimisation of war. It works towards world peace and total disarmament and the abolition of violence and coercion in the settlement of conflict. WILPF supports the continuous development and implementation of international law and promotes political and social equality and economic equity. In other words, WILPF aims to achieve a just and equal world, free of war and violence, where everyone has the full benefits of human rights. This is WILPF's centenary year. Our 2015 conference was about establishing the principles of sustainable peace building and exploring the root causes of conflict, as was done at The Hague by our foremothers in 1915. This means approaching peace building from a holistic perspective, taking into account human rights, disarmament, social and economic justice, and challenging the ongoing, increasingly militaristic solutions to achieving security. So, WILPF is a human rights organisation, and it's unashamedly a feminist organisation. It focuses on the real concerns of women living in conflict and post-conflict affected societies, on who has the power and on who wields power. Our Secretary-General, Madeleine Rees, in her introduction to the recent webinar on a feminist foreign policy, said, and this is absolutely fundamental, militarisation is the enemy of human rights. International humanitarian law is the law that prevails when normal conditions don't exist. This means we have the question, so is international humanitarian law an ally of human rights law or an ally of militarisation? And if the two overlap, if IHL and human rights law overlap, what does this mean? How does international law protect women compared with domestic law? How does it advance gender equality? If, as suggested, the two systems, IHL and IHRL, are becoming increasingly entwined as the nature of conflict changes, how can they be interpreted to provide a gender-sensitive approach to conflict? Should they be doing this? Or, as we increasingly ask, is it simply making war safer for women and not playing any role in preventing or ending war? The even bigger question, though, is how can WILPF use these two systems to help advance gender equality and prevent or end conflict? Or do they actually hinder WILPF's achieving these objectives? So hopefully during the course of Jane's presentation tonight, we'll find the answers to some of these questions. Thanks.
Thank you very much, Barb. All right. I would now like to introduce you to Jane Bowness, our WILPF Australia intern. Jane is an international relations and law student at the University of Queensland with a keen interest in public international law generally. She's also passionate about furthering women's rights in particular and the role gender can play in addressing global issues. And this year she was granted a place in the Women in the WILPF intern program in Australia. So I welcome you, Jane.
Thanks, Chris. I'm just getting my video up.
I understand.
Hi, everyone. Good evening or good morning, wherever you are. Thanks for attending the webinar, obviously. Tonight I'm going to be presenting the findings from my report that was produced for WILPF in the internship program over the last few months. The purpose of which was to examine the link between IHL and human rights law from a critical feminist perspective, obviously. And I basically used a literature review method in doing that. So the aim was to make it a legal report, but ultimately for it to be accessible to activists and WILPF members, obviously. So I just wanted to quickly say as well, the WILPF internship program was such a great opportunity, and I'm really grateful that I got to work with such great women, Chris, Barb, and Jeanette especially. So if we get into it and crack on, I'll start with some definitions, because while more of us are familiar with human rights law, humanitarian law isn't as well understood. So it's otherwise known as the laws in war and regulates conflict. And its basis is the Geneva Conventions, which you probably have heard the name of. So those aim to protect vulnerable groups during conflict. The Geneva Conventions were first open for signatory, signed in 1949. But prior to that, there were always customary rules of engagement in lots of different societies going back years and years. But historically, or in modern times, IHL is primarily motivated by a principle of humanity, not rights. The most important aspect to that is neutrality. So IHL considers itself to be a neutral regime, allowing all parties to a conflict to still gain tactical advantages through the use of force, and as such, it's said that it ensures reciprocity. So in that way, it really only provides for base level protections, minimum requirements, so it's just the line that you can't cross, and in that way, I guess I'd give it a criminal characterization. So it's fairly well recognized that the Geneva Conventions are considered customary law as well. That is, that they're binding on all states and not just those that are signatory to or have ratified the treaties, unless they're a persistent objector, which is some legal jargon that if you're interested, I'm sure there's a wealth of resources you can read up on about customary law. So in that way, international humanitarian law is definitely more of a universal regime. And I just wanted to note as well that the Red Cross does play a really important role in the development and enforcement of IHRL. So we often look to them. On the other hand, oh, Chris, you might just want to change the slide. Thanks. So moving on to human rights law, which is more commonly recognised, and I'm sure most people here would be familiar with human rights, especially how they relate to gender and women's rights in particular. Human rights law is a newer concept, so it developed out of the end of World War II with the Universal Declaration of Human Rights, and they're seen as laws that traditionally regulate the relationship between the state and the individual during peacetime. So they were put into place really as a safeguard, a preventative measure, so that none of the atrocities that did occur in World War II would happen again. They are much broader than humanitarian law, both in the wide sort of range of areas they cover, but also in terms of like the substantive content of individual human rights treaties and norms. If you look at CEDAW, for example, or even the ICCPR, you can fit them all on a page, and they're really, most of the norms are kind of statements, one-line statements, or what critics would say is they're quite aspirational in their nature, whereas the Geneva Conventions, you could fill sort of books with them. So human rights law is a lot more broader than humanitarian law, I would say. In that way, it's more like public law than criminal. So you can think about it more, for people that aren't familiar with international law, as you're suing people through committees or suing a government rather than someone being prosecuted for a crime or an act. Some human rights law is customary. So, for example, norms against genocide, slavery, and torture are all considered customary law. However, most gender-specific rights sit within the realm of treaty law. So, for example, you've got CEDAW as the main one. And within treaties, it's sort of more of the economic and social realm, you would say, especially of the UN. The Economic and Social Council covers a lot of that. So human rights law is also much more politicized, and it becomes an arena of political struggle rather than setting standards for minimum protection, which is what I would say is what it's meant to do. It's meant to be the law. And you can also see this in often state governments particularly make arguments around human rights depending on what side they're on. So you have certain parties saying, you know, you can't do this because of human rights, so using them as a tool, how they were meant to be used, but still as a political tool. And then you have other parties, for example, my thought for Australians that would be relevant is the ex-Prime Minister, Tony Abbott, using the phrase that Australia is sick of being lectured to by the UN about refugees. So you can see both sides of the coin there. And it is also commonly known it's more controversial than humanitarian law. So if you just want to change, Chris, again. In terms of the critiques of these regimes, my report considered feminist critiques of both. It's important to note generally feminist approaches to international law recognise the dichotomy of the public and private spheres and the relegation of women's lives to the private realm. Same as feminist critiques of domestic legal systems. So both regimes have been constructed on the male experience, and that's at their core. However, I thought overall it's important to note that human rights law treaty making is, and just the human rights law regime in general, is a little more modern, I would say, and not so restricted in that. And also, I just want to say from the outset, enforcement arguments and about whether international law is law or whether it matters, they permeate all areas of international law, so I'm not going to go into them too much here. So starting with humanitarian law, there are two schools of critique there. There's the enforcement school, which, as I said before, basically humanitarian law does work for women, but it's not enforced correctly. And then there's the revisionist school. So the revisionist school reveals the real feminist critique of the substantive law. The first point that the critics talk about is the neutrality approach. It's often used to defend humanitarian law for its lack of gender-sensitive provisions. For example, humanitarian law has the no adverse distinction rule. So it prevents the regime from giving priority to anyone, including those perhaps in more urgent needs. So everyone's to be treated equally, which sounds great in theory and provides structural equality, but gender-specific vulnerabilities are left out of the equation there. So obviously also it is an older regime, created in 1949 with the first Geneva Conventions, and so it's gendered in conception and also gender biased in practice, in that because it was conceived in that way and built on these masculine ideas of how wars should be fought, the supposedly neutral conventions can never really address the female lived experience. So following on from that, another point's made that where there are gender-specific provisions in humanitarian law, for example, the provisions against sexual violence, they're still written from that kind of male public domain. So the articles regarding sexual violence case the articles in terms of honour and dignity crimes rather than an offence against the person, for example. So the dated stereotypes that a raped woman is dishonoured and her family is dishonoured, like women as property, are all reinforced there. These offences, in the report I say these offences should be framed in a way that dishonours the perpetrator, not the victim. So furthermore, another part of the critique goes into the definition, especially of war crimes and crimes against humanity. Both have public elements that are not often satisfied by gender-based crimes, and they relegate, therefore, the lived experience of women to the private sphere again. So the requirement of a crime against humanity that it be widespread or systematic is accepted. That's really the point of having those crimes. But to require proof of a policy being implemented in carrying out the crime is unrealistic in many conflict situations and places too high of a burden on victims of gender-based crimes and sexual violence. Also, you can't overcome it just because sexual violence and rape have been found to fit the definition of torture under the Torture Convention, because that convention requires state action to be present and that the rape be for a deliberate purpose, for example, to elicit information or something like that. So again, that doesn't fix the problem, and it shows how the private-public dichotomy permeates humanitarian law, and the female experience does tend to fall through the gaps. In terms of human rights law critiques, it's also subject to similar criticism in terms of its gendered nature. So the arbitrary primacy awarded to civil and political rights by Western international lawyers and organisations displays sort of the public-private divide again that persists in human rights law, especially where the same importance hasn't been placed on economic and social rights, which often govern life in the private sphere and therefore the world of women, basically. There's also implementation arguments in that human rights law is considered political, and so many treaties don't have committees or state parties are not signatories to protocols which set up the committees, and therefore there's no sort of mechanism to hear complaints. So I know, for example, Australia didn't sign straight up to the CEDAW optional protocol, which established the committee. And then another kind of critique, sort of going through them like this at the moment, the Asian values critique. Any sort of Pol student will have heard of this one. It conceptualizes human rights law as a political creation of the West, and it's the primary political argument made against many human rights standards. So where humanitarian law might be characterized as agreeable to almost everyone, every state, human rights law is often labelled controversial. So in a way, this sort of critique seems to be cut from the same cloth as a feminist analysis, in that human rights law as a regime is biased, given its formulation by white men after the atrocities of World War II, with norms defined by what men feared would happen to them. But despite this, the Asian values standpoint is generally used to argue against the furthering of women's rights through a more gender-sensitive approach, because of the traditional status of women in many Eastern cultures. So it doesn't work out very well there either. Also, some final little points. Often, human rights law is often characterised as aspirational. As I said before, it's very broad and not seen by everyone as proper law. So, as I said before, CEDAW's one page. The Geneva Conventions fill multiple books with content. So the nature of the norms is not very specific and kind of open to interpretation anyway. So how do you enforce something like that? So I would say, however, for human rights law, there are more treaties and more gender-specific norms. So it's more modern and it's more capable of sort of innovating itself, because there are so many different aspects to it, especially, whereas you've got humanitarian law is really based in those Geneva Conventions from 1949. So Chris, if you just want to change the slide. I know that took a while. Sorry, guys. So my research question was, given that international human rights law contains more gender-specific content than humanitarian law, can it fill the gaps that we've talked about that have already been identified in humanitarian law to provide greater protection and better outcomes for women in conflict? So, shall we answer it? Can you please change, Chris? So, yes, it can, and I've got examples of this. The definition of persecution under the Refugee Convention in 1990 by the UNHCR was defined as inclusive of discrimination as prohibited under CEDAW. So that's, I think, the ultimate example of the complementarity approach in action. So complementarity means, as far as it's possible, these two regimes, IHL and IHRL, should be read together and interpreted together. So you take meaning from each and make them sort of mesh with each other. So nothing, interpret as far as possible together, basically. So Security Council Resolution 1325, I think, is another example of that. It calls upon states to respect fully international law applicable to the protection of women and girls, including the Geneva Conventions and the Convention on Elimination of Discrimination, CEDAW. We'll just say CEDAW. Also, I've got that the UN attributes groundbreaking decisions of the temporary tribunals, the Criminal Tribunal for the former Yugoslavia and for Rwanda, to the headway made by civil society on women's rights issues, so women's human rights sort of organisations, since the Beijing conference. These tribunals, though it's important to note, were not restricted by the new statute for the International Criminal Court. It hadn't been adopted yet, and thus they took a more gender-sensitive approach than current humanitarian law. For example, they included rape as a crime against humanity without any public official element, just that the crime be committed in armed conflict and directed against any civilian population. So, and they really, I think the temporary tribunals are really good examples of how you can, if you can mould the framework to be a little bit more specific to each conflict situation, it is a lot more successful, because that's where there have actually been prosecutions for gender-based violence and sexual violence and convictions out of it. So that was the, in the former Yugoslavia, that tribunal, there were cases of ethnic cleansing through sexual violence, like enforced sterilisation and rape, that included. And it was also the first to interpret rape as torture, first case of sexual violence against men, and a lot of other really groundbreaking decisions. So if you've got time to read a judgment, which not a lot of us do, have a go there. There's also, I wanted to say, evidence in the preparatory works of the International Criminal Court statute that bringing a more gendered perspective into IHL was considered with the recommendations of the Women's Caucus for Gender Justice. However, these recommendations weren't followed through with. So if you just want to change the slide, Chris. So complementarity, we can see, can help women. We can combine these two regimes to really produce more gender-sensitive outcomes. However, it's only to an extent, because the lex specialis principle, which means the more specific law overrules the more general law, applies in international law. So it generally, in armed conflicts, this means that humanitarian law, which was originally made for regulating conflict, will apply instead of human rights law, traditionally the law of peacetime, obviously. So there is an option here that lots of human rights organisations fall into the trap of, which is that the human rights law trumps all. So it applies all the time, no matter what, every provision. And the courts have basically said no to this. Even where this may yield a fairer result, it's not a legally sound method, because it affects the sort of systemic integrity of the system as a whole, including human rights law. So it sort of negatively affects itself, in that you're overruling the previous sort of well-recognised interpretation without proper reasoning, is basically how you put it in legal speak. I mean, an example is where decisions of the European Court of Human Rights especially try to overrule sort of Security Council resolutions, I guess you could say, with human rights norms. So a couple of cases to look at there would be Algeta and NADA and Switzerland. If you want actual cases, you can message me later. I don't think it's super relevant for everyone, but basically it is important that we recognise human rights do not apply all the time and cannot apply all the time in their current form. I hope that one day they'll be able to apply all the time, and I'll get to potential reforms there soon. So Chris, if you just want to change. So I then went on to look at a case study. It was quite brief, just to see how these top-down legal frameworks, big international sort of regimes, apply on the ground, which I think is activists are always interested in, and especially, I mean, civil society generally. So I had a look at Afghanistan. So first, the legal protections generally and how they're felt. I looked at the report of the prosecutor of the International Criminal Court. So currently, Afghanistan is a country at the admissibility stage of reporting. So they basically are reports produced that looks at the potential crimes that may be prosecuted that have been perpetrated in Afghanistan. The current gaps are really evident when you look at this report. So we know about the scourge of gender-based violence and other violations of women's rights, like to education, for example, that occur in Afghanistan all the time. So you only need to look at, WILPF members will know the Peace Women database or Human Rights Watch, for example, to see that. However, there was only one report that really, one incident that seemed to cover a gender-based crime. It was the bombing of a public building under the war crime of intentionally directing an attack against a building of education purposes. And the report suggested also possibly a war crime of persecution based on gender grounds because it was a girls' school. And it was attacked under the Taliban's policy that women should not be educated. So I think it really provided the example that that was the only crime they were even talking about. It's quite dire that you have to focus on the building, this public building, rather than the effect of gender-based violence on women's lives to achieve anything under the current humanitarian law model in terms of prosecuting. In the same report, the public-private dichotomy was really evident in that it's much easier to prosecute a gender-based crime where there's a public official involved. So I've got there in the same report there are at least 109 counts of rape and other forms of sexual violence attributed to the Guinean government under military rule. So that's from violence perpetrated by public officials. So it sort of picks up a little bit more that way. But the changing nature of conflict means that you can't rely on wars being carried out like that. I mean, you just have to look at the situation in Syria at the moment. It's so multifaceted, and I don't really think that IHRL is keeping up there. In terms of human rights law being implemented in Afghanistan, there was domestic legislation which implemented the National Action Plan for Security Council Resolution 1325, and also CEDAW was imported into that. The Constitution also now recognises women as equal citizens. However, there is a lack of funding and political disintegration that has put the brakes on for the implementation of women's rights. But legally speaking, the human rights law treaties in that way have had the greatest influence in terms of women's rights and sort of furthering the state for women there, not humanitarian law, which we can see here has really failed. So I had two questions that arose out of my case study. Is humanitarian law really the lex specialis in this situation? And would any reform of humanitarian law by the removal of that organisational public official policy element for crimes against humanity and war crimes, and I guess torture as well, under the Rome Statute, under the statute of the RCC, yield any better results? So that's kind of what had me thinking for further research down the track. Chris, if you just want to change the slide. So secondly, in my case study, I looked at the more grassroots level effect of the two regimes in that these regimes both guide organisations that prescribe to either one or the other approach, and this really guides them in quite different directions. So, for example, humanitarian organisations that prescribe to humanitarian law as their sort of guiding principles, like the ICRC, have been criticised that throughout the conflict period, Afghan women's rights have come second to ensuring the organisations retain their presence and maintain operations and continue their dialogue with all parties. respecting their principle of neutrality in that way. So, for example, the ICRC provides health services for persons irrespective of location, political affiliation, and they also provide food aid, monitor prison conditions of all parties, and limit any public criticism of all parties. So they avoid any conditions on aid. So, for example, the Taliban edicts on segregated health facilities didn't affect the support of the ICRC to their wounded. So, and some would argue, there's many differing opinions on this. Some would argue that keeping that approach does keep you there, keeps you talking to each side, and you can achieve more that way. I would probably, obviously from my report, I've critiqued that. I believe that, and from the resources have found that international human rights law or human rights organisations, I guess, that are guided by human rights law are more able to adjust and more innovative. So, for example, UNICEF refused to support schools for boys as long as girls were forbidden from attending classes. So, and more funding is offered for girls-only schools. So that's a really simple kind of way of seeing it, but also the idea that you are allowed to speak out and publicise your views in a human rights organisation, or publicise that women's rights, for example, aren't being respected, gives you a lot more leeway to kind of change people's opinions in the country, and especially in Afghanistan. So being able to soften the views of Afghanis and create social change really was the role of the human rights organisations in Afghanistan, is what I've found. Chris, if you just want to change the slide. So my future research, I mentioned before that obviously because of the Lex Specialis principle, reform of IHL is necessary to yield a more gender-sensitive approach to conflict. Further data also, this was a big one, really needs to be collected from women in conflict zones on their experiences of war, and obviously that's so hard to do. It's really hard to get primary data from a war zone. That's not going to change, but hopefully moving forward in this age, we can sort of start to get some more data there, especially in Afghanistan. Also, I think to determine to what extent a top-down legal approach really affects and improves the lives of women compared with what civil society do. I don't know, I think that from just briefly looking at the work of NGOs in Afghanistan, in one country, there's just so much that can be achieved when you are not so restricted. You're not waiting for something to come to you. You can take the affirmative action. Also, some analysis of the jurisprudence on the Lex Specialis principle specifically, which is what I said before. In these situations regarding women's rights, is humanitarian law really the Lex Specialis there? Is it really the one to apply, or is human rights law more specific? However, segue from that, there's also the issue of human rights law here. It's being too broad in its current form. As I said before, it can easily be characterized as aspirational, and that's really holding it back. So in terms of like anti-discrimination specific human rights law applying in armed conflict, it was found by the ICJ in an urgent provisional measure, which can be taken with a grain of salt, but, you know, still the ICJ, that the Convention on the Elimination of All Forms of Racial Discrimination applied, even if the alleged acts which breached that convention were also covered by other rules of international law, including humanitarian law. So when you compare CEDAW and CERD, I guess you'd call it, the Racial Discrimination Convention, you can see even a slight difference between those two. CEDAW is even more sort of general than the other anti-discrimination convention. So, I mean, I think that's something for civil society to really work towards in terms of making sure that we get some more specific sort of outcomes through as human rights norms develop. And I know that's hard, especially for to get a very universal, specific outcome because of the controversial nature of especially women's rights and gender rights. So that's always going to be a problem, but it's something we can keep working towards. Chris, if you just want to change it. Last one. So I just put this in because from undertaking this research and doing this report, what I would like people to take away from it, and certainly what I've taken away from it, is that we really need to synthesize, as Barb said as well at the start of this presentation, we really need to synthesize the top-down approaches of the two regimes with grassroots approaches that organisations like WILPF encourage. So it's definitely an important process of the an important part of the process of the reform, and maybe the most important in terms of the action of civil society. So we really need to make sure that we're reconciling the policymakers and what's happening in that Security Council room, chamber, with what's happening on the ground. And I think civil society can really be the one that links the two together through only through really understanding what the regimes are and how they can work together, as well as bringing your knowledge from sort of that grassroots level. So thanks everyone for listening. I hope that didn't go too long for you, but it was a great privilege. Thank you.
Great. Jane, thank you very much. That was excellent. And it was certainly, I mean, there's so much ground to cover, isn't there, around these topics. So excellent.
And I just want to say as well that I'm a student that's got an interest in it. I'm sure there's a lot more that you could read, and I know there's some handouts on here too, but yeah, definitely a lot more depth that you could go into.
Yes, indeed. Okay. And I guess what I'd like to do now to everybody is to, you will no doubt have some questions that have come to mind, or some areas that are not so sure about. Please put those questions into the question box. What we'll do now is we have one more speaker present here with us, and that's Barbara Dwyer, who you've already met, and who will comment and make some commentary on the issues that Jane raises. And then we have some other panellists who are perhaps more here in spirit, who would like to contribute too. And so I'll share those with you in a few moments. And in the meantime, I'd like to point out that there is a section in the webinar, in your little webinar box, where you should be able to find some articles that we've uploaded. One of those is Jane's report. And then there are a couple of others there too, which I'll refer to, which you might find useful for those with a particular interest in this area. Okay, Barb.
Can you hear me?
Yes.
Yeah. Look, my mind's boggling a bit, really. That was wonderful, Jane. I'm not sure whether many of the audience perhaps are lawyers or have a much or do have an in-depth understanding of both IHRL and human rights law. As someone who's worked in the general field of gender and peace building, and you just flashed up the picture of Helen Durham, who was somebody we always really relied on for her commentary and her expertise on international humanitarian law. But for someone who's worked in the gender and peace building field for many years, I think that was so good to have that explanation of how IHL links with human rights law, because when you're working sort of in a general way with it, especially with IHL, it seems to be a very neutral set of laws, if you like. There doesn't seem to be anything that applies to women specifically. And so it's gender neutral, I should say, or perhaps not even gender neutral. It seems like a very masculine set of laws, because you talk about during conflict. I mean, we talk about soldiers' cards. Soldiers have actual cards, laminated cards that they take, and depending on what level they are, whether they're private, a corporal, or an officer, they have a different set of cards telling them what they should and shouldn't do. One of the things that's been talked about recently is to actually, and I don't know if this will ever eventuate, but for them to include, and this is really quite controversial, but whether they should have included in their cards what they should do to report sexual violence during conflict. Now that's very controversial, and I don't know whether
that sort of furthers the whole idea that the women are always the victims and the men are the soldiers, and it's their responsibility to protect the women. And I think that you can see that as well in the Geneva Conventions. It's really underlining it, all these assumptions about protector and the protected dichotomy type thing.
But also, is that something that soldiers will be literally qualified to do? I mean, that's a very risky area to get into if you're talking about dealing with women who have been sexually assaulted, no matter what the circumstances. So look, I won't talk much more, because I really think people should have a chance to ask questions. But I just found that so. I found your presentation it was extremely useful, but it probably raised even more questions that I'd ever had before. So hopefully it did for everybody else as well, especially the links with CEDAW and with 1325. So it's not just those two areas of law as in the legal sense, but that much broader sense, because 1325 isn't a law, and CEDAW is a convention. So there's just so many cross sections that apply. So I hope that means that lots of people in the audience will go and searching for more information, and that within WILPF we can actually use this as something as the basis for a lot more action on our part. Thanks, Jane.
Oh, thank you, Bob.
Right. And thank you, Barb. And I'd like to say that my apologies, I've got a barking dog outside our place. So I will probably, what I might do actually is mention a couple of the questions, then I'll turn my sound off, and then we can come back in with Helen Durham's comments and others a little bit later. So the first question that's come up is, how does your reform incorporate private military companies?
Well, I guess obviously I do look more at the public law side of things, and that's what I've really gone into in my report. I think that's definitely somewhere that is a whole other area that I'm certainly not well read on, and the whole sort of intertwining of corporate warfare. I mean, there's always going to be that issue as well, in that humanitarian law and human rights law international law generally is failing to develop quick enough for the way that conflict's developing. A lot, for example, I mean, you can't even, you can prosecute individuals in the ICC, but to take, you can only take states, for example, to court, if you like, to the ICJ, or in like Europe, you have to have a complaint against a state. So I think that's more of, for me, I'm not well read enough on it. I don't want to say that I've sort of come up with this all-encompassing reform, but I think that's a critique of international law generally. It isn't keeping up to speed fast enough because it's so cemented in those, especially humanitarian law, is cemented in those sort of 1949 conventions where it was, you know, it's the Allies versus the Axis powers. You know, it's all state military, and now it's certainly not like that. Not just with sort of corporate, military corporations, I think is what is the term used. Not just with that, but with not different types of non-state actors. We can see, again, I mentioned Syria because that's the relevant conflict at the moment, but there's IS, there's also the different sort of rebel groups. It's so much more complicated now, and I think that I would be unwise to say that any sort of reform that I've come up with, I haven't really come up with too much reform here. I haven't really said what the reform should look like, but I think I'd be unwise to put one forward at all, really. I think that those problems are just all-encompassing, and yeah, definitely something that needs to be thought about
Great.
continually.
Thank you. I've just noticed that Jeanette, actually, from Australia, has made a comment, follow-up comment. Sounds like private military companies would be a good area for further research in the IHRL complementarity area. Yeah, thank you. Okay, well, look, now things are quiet in my area of the world, I might come back to include the couple of the comments that we've had from significant researchers and practitioners in this area. The first one of those is Dr. Helen Durham. Now, Helen is actually, well, many of you will know of her, Director of International Law and Policy at the International Committee of the Red Cross. She's one of the world's leading international humanitarian law lawyers, and now, yeah, the first woman to head this whole legal area of the Red Cross, which, you know, and it's the Red Cross who are actually the custodians of IHL. And she also is one of our WILPF Australia centenary peace women who we acknowledged this year. So Helen's comment, I'll move on. Read that out. A gender perspective on IHL insists on emphasising two principles. First, that where women and men participate in war, their experiences should be recognised as valid rather than being excluded from the discourse or reduced to stereotype. And secondly, that IHL norms apply to all participants in war in both a protective and a regulatory sense, regardless of gender. So, yeah, so Helen wished this initiative, the webinar, and our working internationally together to look at this area the very best, and yeah, said that it was certainly important and needed. Would either Barb or Jane like to comment on that? Or connected with our earlier conversation?
Yeah. Barb, do you have anything to say? I think that is right. Of course, Helen Durham is amazing in the field. Yeah, I think that really supports the whole idea of that IHL. It is really important to take a gender perspective when you're applying that. I think the second part of her statement, that IHL norms apply to all participants in war, both a protective and regulatory sense, regardless of gender, that is the neutrality approach encapsulated, which I have to say obviously in my report I did critique, but her first part really, I think, shows how there are great sort of minds, especially at the Red Cross, that realise that women are left out of the equation, and they do need to be really included in the discourse, obviously.
Mm. Okay, great. Barb.
Yeah, look, I guess this is one of the areas that becomes problematical for anyone committed to WILPF's principles, because we're talking about participating in war. You know, not only more women participating in war, we want less men participating in war. So there has to be laws or rules, whatever, that apply to everybody. So, you know, given that both men and women do participate, then those norms should apply to all participants. But men and women, I mean, even when women are participating in war, they're often participating in a very different way. You know, if you look at what happened in East Timor, for instance, there were many women involved in the independence fighting in East Timor, but it was more in that sort of service way, where they were fetching and carrying and taking food to the men who were fighting out in the jungle. I'm not sure whether IHL recognises those differences, you know, that yes, you've got both men and women participating, but does IHL recognise what the differences are in the way they participate? I mean, not everyone's got a gun or are out actually doing the fighting.
I definitely agree with that, Bob. It was, I mean, it's only recently that on the other side of the coin, not only that women participated in war, but it's only since the what I was talking about before, the temporary tribunal for former Yugoslavia, that it's been found that men can be a victim of sexual violence, which is another, you know, I don't want to be the one to make the whole men suffer too argument, because obviously it is far and away women are the victims, but, you know, you have to not just have a women's rights approach, but a gender sensitive approach. I agree. Like, humanitarian law does seem to miss that a little bit, I think.
Yeah. I mean, from a gender equality perspective, if you don't do a gender analysis of any situation, you never know what the differences are between men and women's circumstances, and what you should actually be doing to apply. Why should you might want neutral types of laws that don't discriminate against either men or women, but you want to make sure that you have laws that actually account for the differences between men and women as well. So I just feel that, you know, because IHL and even the human rights law, you know, they were invented, if you like, or long before, you know, the modern women's movement, who really understands about gender analyses and gender strategy. So I guess I'd like to see some sort of reform, whatever you like to call it, of particularly of IHL, so that it really does recognise those differences.
Okay, thank you. All right. I'll move on quickly to the next researcher. Of course, we're getting a wonderful array of questions, and it would be great to really get into those. So Dr. Nicole George is a senior lecturer in peace and conflict studies at University of Queensland in Australia, and she's also done a lot of work on the ground in Fiji, both in a working mode and a research mode, who has said very valuable paper. And more and more in the field of peace and conflict studies, we're trying to understand how the local and the global interact. So she's, you know, really looking at that interaction, which I guess is what we're picking up in things like Syria and, you know, Afghanistan. And what does the literature have to say about the interplay between these international justice frameworks and the operation of local systems of justice, which are often vital to the achievement of reconciliation and post-conflict transition? and which sometimes, though not always, allow women's voices to be heard and carry more weight, as occurred in Bougainville, for example.
Yeah, I think that's obviously the report that I did focused on the big sort of top-down international legal approaches, but how those filter down through not only to the state governments and to civil society, but also, you know, regional alliances like congresses of, you know, Congress of African states or a Congress of Asian states is really important, because in that way, as you get the norm filtering down, you can get a more, I think you do get a more successful and sort of, it's the wrong word, but suited, I guess, application or like policy. So at the, as I talked about, the tribunals, they were just for one region and sort of one conflict basically, or multiple issues, but one sort of period of conflict, and it allowed them to really be successful in getting results, basically. And I think that is because it was so centered around, you know, suiting itself to this particular conflict. So those regional and state and civil society even applications of the international justice frameworks are, I would say, often the most successful, and it's really important that we support them and, you know, increasing them as well.
Actually, we have a couple of questions, people contributing, which I think would be most appropriate at this point. And I hope I get your name right. Anjana Regmi says, as a practitioner and an early academic, we work with the grassroots and governments, but specifically with policymakers in gender mainstreaming and gender-based violence in bringing change. This is in Nepal, and we use CEDAW and UNSC 1325 very closely with the Nepal government plan of action.
That's what I've been seeing actually as well. A lot of the national action plans for 1325 and CEDAW really are the more successful. Of course, I mean, that's always going to be the case when it's, you know, something in domestic legislation versus this international quasi law, if you think about it. I mean, you can't always, the right and the remedy are very far apart in, and also, I mean, and also in that way, the policy and the application are very far apart when you're speaking about things in terms of the international regime. Whereas when you're talking at a more local, in a more local circumstance, I guess, it's a lot closer together and a lot, generally, I think, more successful in that application because of it. And also, it sounds great what you're doing in Nepal, whoever sent that question.
Yes, absolutely. So thank you very much, Anjana. And actually, Anjana has also added on too that single women, in brackets, widows movement by Women for Human Rights, single women's groups, is an exemplary movement in many Southeast Asian countries.
Wow, yeah. I'll have to look into it.
Yeah, great contributions and important areas to be exploring. So I'll go on and actually focus on a couple more of these questions too. We've had one question from Raylene who asks, would you say that this is an issue that has allowed the Syrian conflict to continue?
It's so it's complicated. I don't even quite understand all the ins and outs of the Syrian conflict. I mean, I think at the end of the day, so like social change and civil society and is what really prevents conflict. I don't think that, I think if someone wants to go to war, or a group or a state wants to act militarily at the moment. They just do. I don't think that necessarily the legal frameworks, if they were changed in any substantive way, would necessarily change that fact. It's a culture. I mean, you can look at the Iraq Security Council resolution and the sort of the states there, the UK, America, Australia, etc., still ended up, you know, going to war there, despite lots of different opinions on how illegal it was and whatnot. And again, as I said, the nature of conflict is changing, and human rights law and humanitarian law aren't keeping up with it. That's correct. But I mean, whether law ever keeps up with social change and cultural change is another question. I think that preventing conflict is really the place of civil society, and obviously working together with state governments and that type of thing. But I think you also need, for example, if you want to prosecute someone, you also need civil society there, you know, notifying the ICC and notifying governments that there are rights being violated and that there are humanitarian laws being violated, like the ICRC. And I'm in a conflict like Syria, it's quite hard to get that information. I mean, no one even knows what sides all these people are on. Like, it's very complicated. I can't provide a complete answer, but I don't think reform of legal frameworks does, like, stop conflict. No, I think that that's a bigger, like, ending war is a much bigger issue than the legal frameworks, I think. But yeah,
actually, Jane,
sorry,
Raylene, that's okay, it's good. Raylene has added on to that the previous question was related to IHL, IHRL, and multinational laws related to private military companies in conflict regions.
Right. Can I?
Oh yeah, right. Yep.
You go, Barbara.
Can I just add to what Jane was saying? I mean, the whole point of 1325 and partly the point of the national action, all the national action plans that exist now in the world, really it is about the participation of women in peace processes with the ultimate goal of preventing or ending conflict. And Syria is one of the examples where that just has not applied. The talks that were held in Geneva last year had no women involved on Syria. So until the whole point is we're trying to achieve gender equality in the way that really does let women's voices be heard, that women are able to say what they think the priorities are for their communities, their societies, their countries. Most, you know, whether and have a much bigger say in whether their countries or factions within the countries should be going to war. This is what this is all about, and we whether we have laws or not, we still have to have that community level involvement.
Okay, thank you. Right, I might go with the next one. What roles for NGOs, e.g. Amnesty, Transparency, International Human Rights Watch, International Communication Crimes Evidence Project, in collecting war zone data, e.g. in Sri Lanka? What do you think?
Oh, such a big role. Honestly, in Afghanistan, I can speak to. I haven't researched Sri Lanka. I wouldn't know exactly where to go, but I would assume that Human Rights Watch especially play a big role there too. A lot of the not just like raw data in terms of an already finished report, but the instances where, for example, Human Rights Watch are the ones that report on when there was recently a Afghani sort of one of their regional courts mandated rape as a punishment to these two women whose brother had committed adultery. Like, that's where you get that sort of information and you really see the depth of the issue, and I think that's also important, not just the raw data, but those organisations are really the ones that are collecting it. I know that for my report, that's where I had to look. I looked at Human Rights Watch, the Peace Women database had a bit too. Reports of the ICRC were okay in that regard as well, because they obviously have a presence in most conflicts. But that being said, because the ICRC does try to be quite neutral in, well, obviously completely neutral in its work, there wasn't a lot on specific, data, not a lot of specific data on gender-based crimes and that type of thing, which is what I was looking for. So I was really looking at organisations like Human Rights Watch, yeah.
Great, thank you, Jane. Actually, that was Marie's question, so thanks, Marie. There's one from Tara here. Now it says question 2, so let me just quickly check back up. Here we go. Thanks for a stimulating presentation. I look forward to reading your paper. I agree that IHL has not sufficiently addressed women's experience in war to date, but bearing in mind these prosecutions have been occurring for only 20 years, the leaps that have taken place are enormous, thanks in part to Helen Durham and others. I am not convinced that IHL needs changing so much, as those who apply it need to understand and incorporate women's experiences. Can you comment? So that's the first part. Jane, you might like to put your screen back on too, if you haven't got it on.
Okay. Sorry, I was just thinking about that one. Okay. First, on your point about for example, the Rome Statute, the criminal court has only been around for, I think, less than 20 years even. How successful that's been is obviously up for debate. The US still isn't a party to that statute, I don't think. There aren't many prosecutions. I don't know. There's a lot of criticism about the ICC, the court itself. But on the other hand, the work that people like Helen Durham do and the ICRC do, obviously, from my report, I have found that it is humanitarian law itself, in its current form, it isn't really gender sensitive, substantively. That's what I've found. I think as well, the people in positions of power and the people that are the policy makers and making decisions, also with that, I agree, they don't take a gender sensitive approach either in their actions, but I think it's a combination of both. It's the whole idea of, I guess, if you don't mind me speaking in sort of generational language, it's the whole idea of liberal feminism versus sort of third wave or more like gender-based feminism in that way, in that you can have structural equality, which is what I guess you could say IHL provides. It is structurally equal in its framework. It's neutral, but that doesn't mean it applies. It turns into substantive equality on the ground. And if people can have different beliefs on this, I mean, that's perfectly reasonable to say you just need to apply the law better. But from my research and my understanding of feminist legal critiques, a law that's structurally sound that still doesn't provide substantive equality isn't a good law. that's my thinking, and I think you know, people are often people often think that we just need that equal structure, but yeah, I like to. I see the other side, I guess, is what I'm trying to say. I'm sort of on the other side of the debate in that if it's not providing some standard of equality, I think the laws need to change. Yeah, sorry.
No, that's great. Thank you. Now, I'm aware that it's coming up to 20 past. So if we spend 5 minutes more on the questions, and then I'll go to, I think, the last comments that we've got on the slide, and then sort of round up and see if we've got any spare time at the end. I also think we could invite people to come to the WILPF Australia website and to continue some of this conversation if they would like to too, because there's still some great questions, I have to say. So going to go through and see the ones that we haven't and perhaps even put a couple of those. One of those from Salah is human rights cannot be applied all the time in their current form. Any further suggestions? That's a big one.
Sorry, just struggled to unmute myself there for a sec.
That's okay.
Well, I guess I have to say that my international law knowledge is comes from a university course, so you obviously get taught, you do get taught a little bit of critical stuff, but you mainly get taught the orthodox positions. And in terms of human rights law, there is a really big sort of contingent in the international legal community that see it as purely kind of in its broad nature aspirational, and it doesn't, in that way, because it has that characterization, it can't set laws and therefore is just a political tool that isn't taken seriously perhaps. And I think there is some merit to that in terms of legally speaking. I mean, if you want human rights law to be guiding principles for NGOs and civil society, that's great. Human rights is awesome for that. As I said in my report, it leads these organizations in the right direction and they really do affect change. But speaking from a legal perspective, if you want these human rights laws to be legally binding or followed, is probably better to say, they need to be it's hard for a state to follow something that is so sort of vague. And it's also, even if a state doesn't or does put action into place, it's hard for then someone else to come in and say, if that's civil society, for example, it's hard for them to come in and criticize or applaud a state for taking action or not taking action, because it's, you don't know if it fit what the convention was trying to say because it's so broad and there's so many different interpretations. I think legally speaking, it needs to be more specific. Human rights law needs to be more specific. But as I said, it's hard to say, okay, well, you can't put a quota or you can't put affirmative action clauses really into human rights law in terms of we want this number of women in this many leadership positions by this date, as you would see, for example, in a company policy, like a private company policy or something like that in life, because this is a global regime and it has to fit all of these states, and it's a very difficult even and I think there's probably people that are human rights gurus that have really put forward even specific norms that they think should be developed. So I think that's worth reading into. But yeah, legally speaking, it's hard for a state to follow something when you don't know what that convention's trying to say to you to do. It doesn't provide for a clear course of action. You know what I mean? I don't know. That's my legal sort of background speaking. I don't know if Barb has anything to add on that. Could be enlightening.
And I'm aware that probably got 5 minutes left too, folks.
Yeah.
Barb, you might be muted.
No.
Okay, good. All right, that's fine. Well, what I might do, if I may, then, just in the meantime, is I'll just finish off. There's one last researcher that we've had that I had some comment from. If I mention, show that online just a little bit. You will have that in your document if you like to download that. But just to quickly bring it in. So. That was the rest from Nicole. So there's Alison Agarwal. She is actually working on cultural reform with the Australian Defence Force. So from the Human Rights Commission, and she certainly reinforces the importance of having both systems be viewed, informed from a gender perspective, and the complementarity approach. Very, highly strengthening, and just whizzing through this, that important for humanitarian organisations to operate from gender and women's right perspective in the course of their work. Now, what Alison did too, she actually highlights in the file that you will be able to download CEDAW Committee's recent general recommendation on 30. Recommendation 30, and noted that was actually, it discusses the complementarity area. It recommends that state parties give due consideration to that in protection for women and girls stemming from international humanitarian, refugee and criminal law. So
I just wanted to mention, sorry Chris, if you go back quickly,
please.
I just wanted to quickly say that's what I was trying to say before, how it says at the bottom there, one of the recommendations of the CEDAW committee was that it recommends that state parties, when implementing their obligations under the convention, give due consideration to the complementarity protections. That give due consideration is like the crux of that whole recommendation. You know what I mean? It's quite, how does a state give due consideration, or what specific protections do they have to think about? It's just all of them at once, you know what I mean? Shouldn't they be doing that anyway? It's quite vague. So I just wanted to mention that, because that was where my critique before was stemming from, because that type of language is what really captures a lot of human rights law. Sorry for butting in. I just wanted to...
No, that's great. Thank you very much. I'm torn now. I don't know if it's okay to continue the webinar on a few minutes longer, because some of these questions are just so great, I think. I'll head through to the end of our slides first off. And so, we had Barbara, and really, I guess this is actually it. You're very welcome to contact me, or to come to the WILPF Australia Facebook page and contribute there, which would be absolutely terrific. What do you think? Would you like to, shall we continue on for a couple of minutes? I think we will. All right, so I've got here, this was a follow-up question from Tara, who said, gender advisors now accompany the Australian Defence Forces wherever they engage, but Defence Forces are too blunt an instrument to implement many aspects of 1325. Thus far, they appear to have been primary carriage, though, of these sensitive issues. How do you see 1325 being more fully implemented? I'm even wondering if that might be a question for Barb.
Yeah, I think Barb should have a go at that one. I wish Alison was here to answer that.
Yes. I think this is the subject for a whole other webinar, how 1325 can be. But that's it's a bit of a pity if that's the impression that people have, that it's only the military who are implementing 1325, because in fact, if you look at all the national action plans, there's over 50 countries that have national action plans. Australia's national action plan is implemented by DFAT, the Foreign Affairs and Trade, which also includes AusAid, as it was subsumed, of course, into DFAT. So it's both the diplomatic and the development side of DFAT. It's implemented by the Australian Federal Police when they're involved in missions overseas. It includes the Attorney General's Department, and it includes the Office for Women as the coordinator of the National Action Plan. So, and of course, civil society is integrated throughout many of those. Many of the actions in the National Action Plan. So it's certainly 1325 is certainly of crucial importance to peacekeeping missions, or missions like the international mission in Afghanistan. But everyone has really pushed, if you like, for there to be gender advisors within peacekeeping or regional missions, because that's, without that, I mean, if you hadn't had, in East Timor, for instance, if there hadn't been a gender advisor in the original, ONTET there, East Timor wouldn't have the Office for the Promotion of Equality, which is an integral part of their government government system. That office advises government departments on gender responsive budgeting, for instance. So there's a continuation of things that you need the gender advisors, you need 1325 being implemented during the missions, the military missions, if you like, but they then continue in all the post-conflict years down the track. So it's an integrated approach, not just for defence.
Great, thank you, Barb. 2 questions remaining. Do you know, we made up a number of questions beforehand just in case no one contributed. It's just been fabulous. So while I read out this, I'm actually going to ask participants if you would like to perhaps just put in a comment at the end about perhaps something that the best part about this, and also whether you would like to have some related topic considered for a webinar in the future. I'd love to get your feedback. So 2 questions here. One of them, did you find men leaving the country and women left behind to take the fight? Most men from war-torn countries leave the country to earn for their family, and who are left behind are young children, women, and the elderly parents. This is from Anjana again, who's been doing the work in Nepal and other places.
And doing the work in the webinar. She's done so many good questions.
Yes.
Certainly there's that element of not just, I wouldn't say so much men just leaving the country, but there is that element obviously of men leaving to fight or to participate somewhat in the conflict, and women, there's definitely the element of women being left alone, and they're the ones that have to make the sort of like day-to-day decisions, look after the family, feed the family, keep communities together. There's really, women do bear, in conflict, women bear a different and often larger burden than, I don't want to say larger and make presumptions, but a very different burden to what men do.
Mm.
And that's where reform is necessary, to see kind of like what this lived experience actually looks like. It's not just women as victims of violence or other gender-based crimes, but it's also women as, they're often the ones doing the protecting, and they're the ones having to have all the responsibility and have to be able to get access to what they need, which in some countries they don't, and all that type of thing. It's
and of course you've got the opposite situation of men staying to do the fighting and women fleeing as refugees across borders. So if you look at the refugee camps of South Sudanese in Ethiopia at the moment, there's hardly a man in sight in those refugee camps. They've all stayed behind to fight. Nearly all the refugees in the camps are women and children. So you've got the opposite situation there. But they still have a tremendous burden.
Great, thank you very much, both of you. One last question and then one request. And this is from Raylene. I think it fits in very well. Would reform then need to not only include differences of gender, but be inclusive of state and non-state actors? Because then, how would prosecutions of crimes towards women gain justice?
Hit the nail on the head, Raylene. Definitely that. Yeah, the whole like state-based, international law is largely still state-based. I mean, you've got civil society and NGOs are being brought into kind of decision-making and that type of thing in the legal frameworks. But yeah, it is still largely state-based. Definitely that needs to happen in terms of, yeah, I mean, you do have the additional protocols to the Geneva Conventions from 1977, which I think were the ones that extended them to intrastate conflicts, so not interstate. That was in 1977, and that was like the kind of last big development that was made. So, I mean, it happens slowly, but in terms of the actual results of that reform, I mean, yes, it would yield results. You've got, I mean, in Afghanistan, the Taliban committed a hell of a lot of crimes. So that would support it in that way, but I just want to say that. I don't want to keep babbling. Yeah, it would help. Again, the same issues still remain with the substantive law. Like, for crimes committed against women, you still have to then get them to the whole prosecution stage and have them covered by the law. So just bringing in the non-state actor thing wouldn't be enough, I don't think. But yeah, it's definitely an element that needs to keep developing. Don't know if Barb wants to say anything on that. I don't.
No, I don't have anything to add to that, Jan.
Okay, great. Oh gosh, actually there are two. So I want to make a comment. Actually, one is a request which I'm going to put up now. Jeanette from WILPF Australia has asked if we could put back up the research slide to be able to consider, what might be the important move, most important areas to be moving ahead at present. So I'm going to go back to that one. There we go. Yeah. So perhaps that might be consideration. And I also am going to read out a couple more questions too. Pardon me. We've just that one. Excuse me. And Jana actually has said who it turns out is in Australia, in Sydney, but we'd love to talk about the widows movement. Yeah, maybe related to how we're implementing CEDAW. That's okay. That might be following up, I think, with you, Jane, perhaps even. And got that one covered. Maybe have a look here. Oh, has the no, I don't know this one. The Brahimi report, in brackets peacekeeping, being used in mapping out specific issues.
That's the Brahimi report, yes.
Oh, okay. Right. So is it being used in mapping out specific issues of gender reform at IHL and IHRL?
I'll let you answer that, Bob. I'm not
sure. To my knowledge, the Brahimi report was totally gender neutral. It mentioned nothing about women and peacekeeping. It was a it was all about the reform of peacekeeping, which was fine, but from a gender perspective, it was absolutely had nothing to offer.
Okay, thank you. And I've just had a little aha moment here that Ashianjana was suggesting that having another webinar, perhaps looking at how we're implementing CEDAW and 1325 and National Action Plan could be a really great one. And there's been quite a few people here, Jane, who have said, thank you, great paper, great presentation, learned so much, and that's been from Japan, from Finland, from all sorts of places too. So yeah, really lovely.
Thanks, guys.
Yeah, I think
Thank
so.
you.
So I think
That's
at that
good.
moment, what I might do is that well, actually, before I do, in terms of future research, is there anything that you feel really jumps out as being the most important one that we need to be looking at now, perhaps within WILPF or elsewhere?
I mean, probably looking at what a lot of people have brought up, and I'm sure they'd love to hear, is what are the substantial reforms that we should make? So some potential sort of, at least start with some ideas as to how to reform IHL. I think that's a good place to start. Not just sort of, I mean, obviously I've given ideas, but more like, okay, what would a draft article look like of the Geneva Conventions if it was to be made gender sensitive, that type of thing. But yeah, that's probably got to be done by much more qualified people than myself. I think as well, obviously, it's not really research based, but the issue of collecting data is a big one because you can't figure out what is the best outcome for the lived experience of women if you don't know what the lived experience is, which a lot of the time we don't in conflict situations. So yeah, that's what I would say the most pressing. I can't hear you, Chris. Yeah.
Thank you very much, Jane. So there are some more suggestions coming up for potential future webinars, and maybe work for interns in Australia and elsewhere might be interested in having a look at too. I think there's just such potential for moving this conversation forward. So what I'd like to do now then is, thank you both, Barb and Jane, very much for your contribution, and particularly Jane for the enormous work that you've done, and to also all of our participants for just superb questions and for your engagement around a challenging area.
And really... thanks Chris Henderson as well for organising pretty much the whole thing. She's done a lot of work on this over the past few weeks, so everyone give a virtual round of applause for Chris. She's done really well.
We're all clapping, Chris.
Yeah. Thank you very much. So what I'd like to say now then, so thank you everyone for attending. If you have any other questions, please contact contact me or come to the WILPF Australia Facebook page. You'd be very welcome to. I'm sure there'll be possibilities for great ongoing conversations. You will, I think, receive a follow-up email with a link to view a recording of today's webinar, which should be great. And so finally, on behalf of WILPF Australia and WILPF's International Office, who have given us an enormous hand in creating our very first webinar, and our presenters, thank you so much for joining us today, and have a great rest of your day or evening.
Thanks, Chris.
Okay, turning the webinar off.